I personally feel that all institutions which are created under the Constitution, which include even our trial and district courts, they must be secular institutions. These institutions belong to all religions. So my basic view is secular is the word in our preamble. Now petition for deleting that word has been rejected by the Supreme Court. So we must respect that, and people belonging to all religions must feel that it is their institution.
Welcome to the Bombay Bar Association podcast. I am Farhan Dubash, and today I have the pleasure of introducing a titan of the law, Justice Abhay Oka. Justice Oak's legacy is one of fearlessness, independence, and extraordinary dedication. From courtrooms in Thane to the Supreme Court of India, he has remained a staunch guardian of rights and the law, leaving behind a legacy of judicial excellence. Your grandfather and father were both highly successful lawyers practicing in the district court at Thane. Can you share a few early memories that you had with them?
Both of them were on the civil side, basically. My grandfather died when I was 17 years old. But I have not seen him as a lawyer much because at the age of 60, one, for the health reasons, secondly, he was associated with various social institutions. He decided to quit practice and continue consultation work. But I have seen him teaching some of the young lawyers, and he was a taskmaster. I could see that. Otherwise, a very soft person. One thing which strikes me is he had developed a huge law library. In fact, he had collection of Bombay Law Reporter, right from one Bombay Law Reporter. And perhaps that was carried forward by my father. We had a huge law library. In fact, we had volume 1 to 80, which I donated to MLLU Mumbai of Bombay Law Reporter. So, image of my grandfather is that he was very disciplined man, and he devoted a lot of time for teaching young lawyers. I could see young lawyers coming to him. I was a very small kid. Talking about my father, he was a strict disciplinarian. In the sense, I can share something with you. He used to tell me to draft a plaint. We had 2 or 3 stenographers working in the office, but he insisted that I should write it by hand. Then he used to correct it and again tell me to write it by hand. The idea is that the draft should register somewhere in my brain. And otherwise also, he was perfectionist. I mean, he never tolerated a single grammatical mistake in pleading, whether it is Marathi pleading or English pleading. And most important thing which I want to share with you is that the day my appointment came as a judge of the Bombay High Court, he had huge work on the civil side at that time. He was representing all the leading companies in that area. He decided to quit practice, active practice in the court. In fact, he never entered the court after I became a judge. He continued to do some work, sitting in his chamber, advising people, teaching junior lawyers. But he returned all the briefs.
Wow.
Because what he felt was that he will be appearing before district judges and civil judges. And he felt that nobody should say that their judgment was influenced by my position. So he did not enter the court also.
Wow,
except for one function, perhaps.
That's amazing. So would it be safe to say that your work ethic and discipline is something that you got from your father and grandfather?
Certainly.
That's good to know. So you've spoken about your years at the Government Law College and being under the spell at 3 institutions: the Bombay High Court, the British Council Library, and the Wankhede Stadium. Now, we can understand why a law student would be attracted to the High Court. But can you tell us a little bit about your fascination with the other 2?
British Council Library in those days was different, where you could go there and sit for the whole day and read the books. And most interesting part was they used to show a lot of films there, maybe video films, maybe regular films. I was fascinated with that section of the British Council where a large number of books on cricket, including the books by Sir Neville Cardus. I was also fascinated by a collection of books on Second World War, about speeches of Churchill. in those days, in student days, I heard Fedun Vitre as cricket commentator on radio. I never knew that he is equally a good lawyer. And in later when I must say that we should be hearing him on television, in television commentary, which we are not doing. And about Wankhede Stadium, in those days, Dulip Trophy and Ranji Trophy had all the importance. So it's fascinating to sit in the north stand exactly behind the wicket by purchasing a ticket worth ₹2 and see Gavaskar, Vishwanath, Vengsarkar, Chandrasekhar, Brijesh Patel and so many greats in action. And in those days, there was healthy competition between Bombay and Karnataka. So it was fascinating to watch those matches and matches between West Zone and South Zone. So that was most enjoyable part of my career during my tenure as a law student. And of course, High Court, I was privileged to hear Mr. H.M. Sirwai arguing before a full bench. I have seen Palkhiwala in action. Of course, I must add that very little I could understand what was the argument going on. But the thrill of seeing Sirwai in action. And that was something which was unforgettable.
Please tell us about your initial days in the Bombay High Court in the chambers of Justice Tipnis.
I worked with him maybe for maximum 2 years. But again, he believed in discipline. And most importantly, he taught me one thing. Whenever a client used to come to him, before accepting the brief, he used to read it and tell the client what was his opinion. He would frankly tell the client that, look, why are you wasting money? Nothing is going to happen. Suppose second appeal was to be filed, that nothing is going to happen, so why you want to waste your money? So that is something which I learned and I followed in practice, and I told my juniors to follow it. And secondly, he was very particular that you should be 100% ready on facts. And third thing which I learned from him is that if there is a binding precedent against you, you should start your submission by telling the court that binding precedent and then argue that perhaps that will not apply to the facts of the case. So these are three things which I learned from him. Discipline is very important according to him.
So you're reading the brief from cover to cover.
Right.
Is that what you've learned from the
Certainly.
chambers of Justice Tipnis, in which
Certainly.
you took to the bench as well?
Right.
Because as in at the bench you were known to have read the papers from cover to cover before the matter started.
There I took inspiration from two judges of the Bombay High Court. One is Justice C.K. Thakkar, who was the Chief Justice, and I had privilege of sitting with him on the first day of my judgeship, and Justice Ajit Shah. I sat with him for almost 3 months in writ jurisdiction, and I could see how he used to read the matters, and so I drew inspiration from both of them.
Because I remember a couple of times when I used to travel from my residence to court and your car would pass me. You were always, your head was always buried in some papers, and one would presume that you would be reading up on the briefs that were before you.
I want to add to this. One of my dear friends who became senior advocate, after I went to Karnataka, Advocates Association gave me a dinner. So after dinner, we had informal chat. They were all my friends and colleagues. So he said that, most of us used to realize that fate of our case is decided from your journey from High Court to Thane and Thane to High Court.
Okay, so on that topic, so Supreme Court would have come naturally to you, especially the miscellaneous days when...
Yes, you're right. In fact, I used to insist that more matters should be listed on Mondays and Fridays, because so many days you will find that I had 80 cases also on Mondays and Fridays.
And you would have read all of them the night prior.
Yes.
Wow.
And especially early morning.
So becoming a judge can be an overwhelming feeling. Can you tell us how you coped with being assigned areas of practice of which you had no previous experience?
This is very interesting because I was 100% civil lawyer. And of course, I had a lot of writ work, 226 work. I remember to have appeared only in one criminal case. It was a criminal appeal. I was sitting in the court of Justice Daud, who was one of our best judges. I was just sitting. He told me to argue that appeal. And I was very tense. He gave me only 24 hours time. That was the only case which I must have conducted on the criminal side. And once I was appointed in by Justice Pense in a detention matter. But I must give credit to my Chief Justices, starting with Justice Bhandari. I remember I had not even completed 2 years as a judge. If I mistake not, in last week of April 2005, I was called to his chamber. And he told me that, look, brother, you have such a long career ahead of you. So from June, for 2 sessions, I am going to give you bail work. And you have full vacation ahead of you. You can make preparation. I was really taken aback because, I felt that being a practitioner on the civil side, I'll get more opportunity to sit on the civil side. But I took up the challenge. First 2 weeks were very interesting. In those days, there was to be only one judge for bail matters, both anticipatory and regular bail matters. First 2 weeks, I could easily notice that most of the lawyers were reluctant to work out bail matters before me because naturally they wanted to understand my approach. Because some of them may have felt that, he's a purely civil lawyer. So he may have what lawyers call as negative approach, which exactly may not be correct. But then I picked up, and I am so glad that Chief Justices allowed me to do criminal work. And then it followed. Justice Swatantra Kumar gave me appeal assignment. Then when Chief Justice Mohit Shah was there, continuously he gave me assignment of those habeas corpus petitions against the preventive detention orders. So it was a great learning experience. I did even criminal appeals division bench. I did a lot of trial work on the original side. I must have recorded evidence in so many cases. I did Section 34. Perhaps only 2 jurisdictions which Chief Justice did not give me. One was income tax. I did a lot of indirect taxation also for 6 months. And second is company law. Otherwise, my Chief Justice was so good that they ensured that I work in all jurisdictions. And that helped me in Karnataka and in Supreme Court.
So you had once said in a talk that you disagreed with the commonly accepted belief that the judiciary is the last resort of the common man. Why?
I'll tell you my personal views about it. I said so on public platforms on the occasion of 75 years of Constitution. My strong personal view is, number one, for all these 75 years, we, lawyers and judges, we are associated with legal system. We kept on patting our back by saying that, common man has great faith in the institution and therefore for him it's a last resort. I disagree with that for 2 reasons. One, as a guardian judge, I had toured many districts of Maharashtra. I was chairperson of the Legal Services Authority. Even otherwise also I used to attend legal services camps. I used to interact with people. Their reaction was completely different. I mean, they used to criticize us for long delays. They felt that we're not getting timely justice. Therefore, based on my experience, I said that, and there is one more reason for that second point, that I felt that during last 75 years, we neglected our trial and district courts. Because these are the basic courts where common man goes there for justice, very few can afford to come to High Court or Supreme Court. Therefore, my perception is that not exactly because common man has a faith in the judiciary that he approaches the court. He approaches the court only when he has no choice.
In one of our earlier podcasts, Justice Patel had mentioned about a scare that you had given him in his early days as a judge.
It started the night before, 19th of June 2013, and Abhay Oka, I had that assignment with Abhay Oka, so I was very excited because tremendous privilege and so on. What I did not realize that the man has a mischievous side to him, and he managed to send those 7 hulking bags, 70, 80 odd cases. And the registry said, these are for tomorrow. For tomorrow, 80. I've never read so much in my life. I was plowing through them till at some point or the other, Madhu says, now look, enough, tomorrow's a big day.
At 3 a.m.
At 3 a.m. or 2 a.m. or something like this. So pack it in. So I did. He's chuckling next day, saying, how many did you read? So I said, about 45. He said, well, I've stopped at 35. A naughty fellow. It's very interesting aside, by the way. Just before this happened, I think Justice Oak's last appearance in court was against me in that Bombay Environmental Action Group Sanjay Gandhi National Park matter before Chief Justice C.K. Thakkar's bench. And I'm very, very happy to say that he lost. So.
Can you tell us something about that incident from your perspective?
I remember he was to be sworn in the morning, I think in June 2013, if I am not wrong. In the evening, Chief Justice told me that Justice Gautam Patel will be sitting with you. And I was so delighted because one of my last cases which I argued was against Gautam Patel in that Sanjay Gandhi National Park matter. And very interestingly, I was opposing environmentalist in that case. So I was very fascinated that Justice Gautam Patel, I knew that he was a very colorful personality as member of the bar. Then as it happens, the registry sends the files in those bags. We call it in Bombay language as labayas. So naturally, Prothonotary or registrar, whosoever was in charge, he must have forwarded those files by a High Court vehicle to Justice Patel's residence. And perhaps he was not aware that he will have to read so many files as judge. So he just called me, I received so many files, what is to be done? I said, you have to read it. But something fascinating I want to say about Justice Gautam Patel. One of my dear friends in the bar at that time had commented that, I used to be very serious in the court in the sense that the number of cases on the cause list used to trouble me. So perhaps Justice Gautam Patel was one judge who made me laugh while sitting in the court. And of course, it was a very enjoyable thing. We differed only on one thing, on quantum of cost. Because his concept of quantum of cost was totally different because I had my background as an appellate side lawyer. And therefore, I don't know whether you heard about it. Sitting in the first court in Bangalore, I used to get many frivolous PILs. So I used to tell the lawyers to withdraw, and I used to say in open court that I will follow the standard of cost laid down by Justice Gautam Patel and another dear friend, Justice Shahrukh Kathawala. And that is the standard of cost on the original side. So it was great fun to sit with him.
So you were the Chief Justice of the Karnataka High Court during the COVID-19 pandemic. Can you tell us something about your time at that instance?
I remember Honorable Prime Minister's speech. It was on the air at 8 o'clock in the night. After I heard the speech, I immediately summoned my Registrar General and other registrars. They came to Chief Justice Bungalow. Then I decided to hold a special sitting in the night because I was worried about all those interim orders passed by various courts. There were orders of injunction, orders preventing demolition, orders preventing reversion of some employee. So I requested Justice Nagaratna, who was the senior most judge at that time, to come to my bungalow. So I summoned the Advocate General, Mr. Nawadgi, and the Chief Secretary. So in their presence, we dictated that order. And while we were finalizing the order, I told the Chief Secretary that I don't know under which act you are going to pass that order of lockdown, but whichever is that provision, please say two things. One, that all the employees of the court will be permitted to travel by showing their identity cards. And secondly, as far as functioning of the courts is concerned, it should be left to the Chief Justice and High Court, which Chief Secretary agreed. I had very enthusiastic and very cooperative colleagues. So what we decided was, as health workers were on the street, we should not be far behind. So we began by starting this, of course, online hearing. In those days, I preferred to use Zoom platform because I thought it was the best. There was some criticism that the Government of India Home Ministry had issued some circular that it should not be used. But I read that circular. It was stated that it should not be used for any confidential discussion or any confidential meeting. And I thought that there was nothing confidential. It was just open court. So colleagues were cooperative. In fact, we gradually opened the court in the sense that I remember either in June or July of 2020, when other courts were struggling to function, we started physical filing. We used to give appointment online. So one slot was given, 5-minute slot was given to one lawyer. And we had opened special counters. We had a lot of open space in the High Court. And that was done in district courts and benches also. Then we started with hybrid hearing. Of course, technically, it may not be that good, but we started that in the sense that we allowed some lawyers to appear physically, other lawyers to appear on screen. And then I realized that this is a time when we can discipline the registry because the filing had reduced. And the grievance was that it was difficult to get the cases listed. People have to mention before the court and take a date. So I decided that every fresh case which is filed must be listed automatically without lawyer moving it. And therefore, we decided, except for bail applications, all other cases, newly filed cases, will appear on 7 days. So if case is filed on Monday, it should come on next Monday. If Monday is holiday, then on Tuesday. And bail applications, I think it was 3rd day or 4th day. And that helped us to improve our disposal. And therefore, if I am not wrong, from September 20 to July end 21, our disposal was more than filing. And in this period, we were able to run all benches normally on VC because we had that privilege of having additional lease line from the government cooperated, BSNL cooperated. And that auto listing in pandemic helped us to improve the image of the High Court. And I must thank my brother judges, they were very enthusiastic about it.
In your farewell speech in the Supreme Court, you mentioned that you never once gave a dissenting judgment. Now, I'm sure you must have had some disagreements. So how would you resolve those disagreements amongst your brother judges?
So I'll answer that question in 2 parts. One, as my role as a junior judge on the bench. You know, when we work in benches, seniority has to be respected. Where when court proceedings are conducted, giving date, giving adjournment, and so many things are controlled by senior judge, rightly so. That's the part of discipline. Therefore, I always felt that if I wanted to disagree with the senior judges, I should do that with respect. And therefore, whenever I used to read the opinion of the senior judge, the draft opinion, I used to go and meet him in chamber and give him my point of view with some material in support. In some cases, I have given a note in writing instead of writing a dissenting judgment, putting down my own views on the subject. And I think that worked and that helped me to resolve whatever was the difference of opinion. And some credit has to be given to my senior judges also, that they were willing to listen to a different point of view. When I started heading the bench, my practice was to take my colleague into confidence. Whenever I used to form a particular view, I used to consult my colleague. If he was agreeable, sometimes I used to dictate judgments in open court. But there were many instances where my colleagues persuaded me to take a different view. For example, I heard a detention matter, habeas corpus petition challenging order of preventive detention. My esteemed colleague who came from original side bar did not have exposure to these kind of cases. Normally, in preventive detention matters, I have to dictate the judgment in open court because it's an issue of liberty. If somebody is to be released, he should be released immediately. But my colleague said he had a different point of view. He came to my chamber and he convinced me to dismiss the petition. And I actually welcomed it. I mean, if somebody is going to correct my views, I welcomed it. And that is how it went on. And as there was only one dissent in last part of my career, I was heading a 3-judge bench. At that time, one of my colleagues dissented.
So in 2002, the Supreme Court issued an order directing that the judge to the population ratio in our country ought to be 50:1 million within 20 years. But about 23 years later, we've not even reached half that figure. How do you think the judicial appointments at the trial court level can be boosted?
This is the most unfortunate part of our legal system. And frankly speaking, very few talk about it. This is one order of the Supreme Court, and that order of Supreme Court makes very interesting reading. It tells us what is the judge to population ratio in so-called developed countries. In some cases, it was 70, some cases it was more than 100. And please remember one thing, in 2002, the Supreme Court considered the litigation which was coming to the court in those days. Now, 23 years have gone by, the litigation increased. The subjects on which litigations are filed are now multiplied. And today we are struggling at 21. This is one. There was one more order subject to correction. It was of 2016 or 2017 of the bench headed by Justice Chandrachud. Professor Mohan Gopal was appointed as an expert to deal with this subject. It was appointed by National Courts System Management Committee. He devised a formula. What should be the ideal judge strength? There was a mathematical formula evolved. Supreme Court said that each High Court has a case management committee. Case management committee should calculate the judge strength, ideal judge strength of the trial courts and district courts required on the basis of that formula and submit a proposal. I headed the case management committee. Strictly going by that formula, we found that we'll need 12,000 more posts in our state. But somehow we reduced it to 8,000 and proposal was submitted. I'm told not even 800 are cleared. If you want to appoint more judges, you require corresponding infrastructure. And maybe priorities of the state are different, so they are not in position to provide us infrastructure. On infrastructure, I want to add, for 5 years, I headed a bench which dealt with the issue of judicial infrastructure. And we had to pass order for construction of various courts. About 10 courts in Maharashtra have been constructed under judicial orders. So unless the government is willing to provide infrastructure needed for more judges, no purpose will be served by appointing more judges. But when we criticize the system for delays, somebody has to raise this issue that in 2012 we needed 50 judges for population of 10 lakhs and today it is only 21. You go to any court, Judicial Magistrates Court in Mumbai, Metropolitan Magistrates Court in Mumbai, you will find invariably every judge has 100 cases or more on cause list. Half of it must be Domestic Violence Act, half of it must be 138 of the Negotiable Instruments Act. How judges are going to deal with these kind of matters?
So on the topic of domestic violence, in a case involving a domestic violence matter, you had decided as a judge of the Supreme Court. You penned a short paragraph referring to how you had taken a contrary view as a Bombay High Court judge and how that view was wrong. What prompted you to draw this special attention to this whilst disposing of this case?
This question has connection with the earlier question. In Bombay High Court, or for that matter, in many leading high courts, judges are dealing with 100, 150 cases every day. In Allahabad, I'm told, judge taking up bail matters or 482 questioning petition, there are 1,000 cases on the cause list. As we are not ideally supposed to deal with so many cases, we the judges are prone to committing mistakes. And I always felt, I said so on public platforms, that we must acknowledge that we are also prone to committing mistakes, and therefore there are higher courts, there are hierarchy of appeals. Even Supreme Court also there's a review and then curative petition. I had indeed taken a view in a case where there was a prayer for questioning proceedings of application under Section 12 of the Domestic Violence Act. Section 12 is the starting process where the victim applies to the court for relief, various reliefs under the Act. So at that time, I felt that it was not a penal statute, and therefore why should High Court exercise its power under 482 of CRPC? The view which I took in the Supreme Court was consistent with judgment of full bench of the Bombay High Court, because my judgment was overturned by full bench of the Bombay High Court. And last part of the judgment I wrote because I wanted to emphasize on this. that we, the judges, are also human beings. We are capable of committing mistakes. And therefore, it is very necessary for us to keep on, introspecting. And therefore, I wrote that last part that we, the judges, we are prone to committing mistakes. And therefore, this is one opportunity for me to correct my view, which was found to be incorrect by the full bench of the Bombay High Court.
So, a consistent feature of your judgments is a deep concern for individual rights, including the rights of under-trials and convicts. Was there any particular moment or a case in your life or in your career as a lawyer that drew you towards this insistence on a rights-based social order?
I learned from my experiences in Bombay High Court. For example, I told you I was given bail sitting. In first few weeks of my bail sitting, I may have denied prayer for anticipatory bail in certain cases. And because I continued for a while, for 5 months or 6 months, their regular bail applications came before me. Naturally, they were arrested. And I suddenly felt, while dealing with some cases, that these were cases where I should have granted anticipatory bail. There was one more case where I remember, I don't have a copy of the order or any particulars. I rejected a bail application where the offense was under section 302. It appears that later on, a higher police officer was appointed, IPS officer, to look into the investigation. Court passed order permitting further investigation. Then it was realized that the accused were arrested earlier. They were not the real accused. And in the subsequent investigation, further investigation, somebody else was named as an accused. Naturally, there was a second bail application after the further investigation was completed, which came to me. That's the practice we follow. Then I realized that what kind of injustice was done to the person who had denied bail. And from there, my approach started changing. And the more you hear criminal cases, you realize that there is a tendency on the part of investigating agencies to frame people. There is a tendency to unnecessarily arrest persons, though arrest is not required. In fact, we are forgetting a basic concept. It is not necessary that somebody is named as accused in FIR, his arrest is mandatory. We have forgotten that basic concept. So it is the experience working as a judge. Sitting in division bench, I came across several cases where accused had undergone 14 years or 15 years. And then we found that there was no evidence against him. That is how you learn. And the last part of my learning was as chairperson of the Maharashtra Legal Services Authority. I must have visited about 8 or 10 central jails in the state or district jails. I interacted with prisoners. I understood what kind of grassroots level situation is. So it was a learning process which made me to take these views. And then I realized that ultimately Article 21 has to be upheld in every case, where liberty has paramount importance under our Constitution.
So during your time on the Supreme Court bench, you dealt with several matters under laws like the PMLA and the UAPA, which give sweeping powers of arrest. How do you think that the judiciary should approach cases under such laws? How does one draw the line between national security and individual liberty?
I think you are asking me a question about the bail, mainly bail, right? According to me, legal parameters for deciding bail applications are well settled. I don't think we have made a departure from the golden rule laid down by Justice Krishna Iyer, that bail is the rule and jail is the exception. Even these statutes like PMLA or UAPA, or for that matter, NDPS Act, powers of the court to grant bail are constrained, but the basic principle remains. Basic approach remains. Actually, this bail is the rule and jail is the exception guides the approach of the judges, because this principle is consistent with Article 21. Now, for example, PMLA, unless the predicate offense is under NDPS Act, the maximum sentence is 7 years. Now, how can you keep a person in custody for 1 year, 2 years, or 3 years when even charge is not framed, because hearing on charge takes long time. Everybody will apply for discharge, judge will have to write a judgment and it will be carried to higher court. So therefore, that basic principle laid down by various benches of Supreme Court, that if trial is likely to be unduly delayed and if there is long incarceration, the case for bail has to be considered in the light of principles governing Article 21. And that is the approach, that you can't use these legislations to punish a person by keeping him in jail as under trial prisoner for a wrong time.
So you've spoken out against the practice of having pujas and lighting diyas at programs that are carried out in the court premises. Can you state your reasons for this view?
I personally feel that all institutions which are created under the Constitution, which include even our trial and district courts, they must be secular institutions. These institutions belong to all religions. And therefore, I always used to suggest better ways of, beginning a function, commencing a function. You can have few plants kept on the dais and watering the plant. That's a very good gesture, because then you promote the protection of environment. So my basic view is secular is the word in our preamble. Now, petition for deleting that word has been rejected by the Supreme Court. So we must respect that, and people belonging to all religions must feel that it is their institution.
Correct. So the biggest problem facing our judicial system is that of pendency of cases. This prompts courts to grant priority to important cases or to direct trial court to decide certain cases in a time-bound manner. Certain legislative enactments like the IBC also do the same. From your public speeches and even your judgments, it is clear that you've thought long and hard about the issue of prioritizing cases, and even authored a constitution bench judgment on this point. Should cases be prioritized? And if so, which ones?
I can give a very interesting example. There is a hospital in Bombay where two groups in the trust are fighting. As a judge of the High Court, I found that every time matter went to the Supreme Court, it came back with the time-bound schedule. Then I felt very bad that I have old cases in Bombay, like for example, first appeal, the 30 years old first appeals. Why should a case where two groups of trustees are fighting should get priority? And that is precisely we have said in our constitutional bench judgment that only because somebody can afford to go to higher court, he can't walk away with an order for giving priority to his case. The priorities had to be fixed on rational basis. For example, we talk about giving priority to cases of 60 years, somebody who's 60 years old. In family court, if a couple is fighting where their age is more than 60, are you going to give preference to that case? Or a case of young couple which is in 40s or 30s? So therefore, priorities is an issue which will have to be decided on rational basis. And that cannot be controlled by superior constitutional courts.
So these days there is a debate about whether there should be a bench at the High Court at Kolhapur. What are your thoughts on this?
My view is this. Firstly, in our country, no other High Court has more than 2 benches. Maharashtra's situation is peculiar. When Nagpur bench was created, it was the principal seat of Madhya Bharat state. Because of reorganization of states, it came in Maharashtra. So it became a bench. In those days, there was a Nagpur Pact signed by various states. Nagpur Pact said that Nagpur will be given a special status in the sense that one session of Vidhan Sabha will be held there. Nagpur Pact also said that large area from Nizam's Hyderabad state came into Maharashtra, Marathwada area. So Marathwada area should be given a bench. And that's the purport of Section 51 of the States Reorganization Act. All this you will find in place in a reported judgment of the Supreme Court in that Narayan Puranik's case, where Bombay High Court had struck down decision of Chief Justice Deshpande of setting up Aurangabad bench. Of course, I must talk about Goa. Goa in that sense is not a bench. When Goa state was formed under the statute, Bombay High Court became a common High Court for Maharashtra and Goa. And therefore, strictly we can't call Goa as a bench because it's part of the common High Court. What I personally felt was Firstly, the High Court on the administrative side, which will be full court, maybe with the help of some committee, some experts, must take a call whether fourth bench will be viable in terms of finance, viable in terms of administration, and even otherwise also. Today, we have a scenario in the state where many taluka and district courts don't have adequate infrastructure. When we think of establishing a bench must have its own building, IT infrastructure, bungalows for the judges, staff quarters, appointment of staff, and library for judges, cars, everything comes into picture. So it has huge financial implications. This is first part of financial viability. The second part is administrative viability. I was a senior judge of the Bombay High Court, being part of administrative committee almost for 3.5 years. I was Chief Justice of Karnataka High Court, which has 2 benches. Managing so many benches is a huge task for the Chief Justice because the administration of the High Court is not only confined to the benches. High Court runs the administration of entire judiciary in the state. So administrative exigencies will have to be considered. So my first point of view is that first systematic study has to be conducted whether fourth bench will be viable. And that systematic study must get approval of the full court. If the answer to this question is yes, we can afford to have one more bench, then rational criteria has to be fixed. There's a report of Jaswant Singh Committee, a 50 years old report, which lays down the criteria. What should the criteria adopted to establish one more bench? Then, if Kolhapur satisfies that criteria, it can be in Kolhapur. If Solapur satisfies, there is demand by Solapur also. If Solapur satisfies the criteria, the Solapur people say that distance between Kolhapur and Bombay and Kolhapur and Solapur, more than what is the distance between Kolhapur and Bombay. So whichever place satisfies the criteria, bench should be established there. So these are the 3 points which I canvassed for last about 6 or 7 years. In 2015, a Chief Justice of Bombay High Court wanted to establish a bench. Then judges, I was the senior most of them, we met him, we requested him not to do it unless this scientific exercise is carried out, and especially when there are earlier decisions of the full court rejecting the proposal. So therefore, unless this exercise is carried out, we should not have fourth bench.
मुंबई हायकोर्टाच्या कोल्हापूर सर्किट बेंचचं आज उद्घाटन. सरन्यायाधीश भूषण गवईंच्या हस्ते या बेंचचं उद्घाटन होणार आहे. मुख्यमंत्र्यांसह दोन्ही उपमुख्यमंत्री उपस्थित राहतील.
I am sure that this process has not been followed, but now there is a bench. Now that there is a bench, I want to say 3 or 4 things. Now, if there is a bench, we must ensure that all infrastructural facilities are made available to the bench at the earliest. It can't continue to be run from old district court building, which was abandoned. District court was shifted to a very modern building. All amenities have to be in place. Secondly, we must ensure that the members of the bar are trained, because practice in district court is different from practice before the High Court. They may be very good in law, they may be very good in procedural law, but they need to be trained, because the idea of establishing a bench is that people should get better quality justice. That is one part of it. So therefore, it is the responsibility of retired judges like me, senior members of the bar, to go there, request the Bar Council or High Court to even start training courses. So now that bench has been established, I find that that decision may not be rational, but now it is there. It is our duty to ensure that the bench functions in very good manner and quality justice is rendered. 2 more things I want to add, which are very important in the context of Bombay High Court. According to me, only 15 to 20% cases will go there, though there are 6 districts. So, because Bombay, the major filing is from Bombay, Pune and Thane. They are the 3 districts, to some extent from Nasik. So therefore, if there has to be a bench in Kolhapur, because today I am told that there will be 1 division bench and 2 single judges. That is not good enough. If this scenario continues, then there won't be final hearing of cases in Kolhapur. So we need to have more judges in Kolhapur. Therefore, immediately, the sanction strength of the Bombay High Court has to be increased, because we can't reduce the number of judges who are available in Mumbai. Only 15% cases are going there. And lastly, this event should not be used by the government to say that now it is not necessary to have a bigger High Court in Bandra. We need to have a very modern and big High Court for Bombay. So nobody should use this to say that now we don't need a huge land in Bandra. So these are my takes on Kolhapur bench.
So can you offer us a glimpse of how you envision your life post-retirement?
These are my personal views, because when I say this, I don't want to say that somebody else is wrong. My personal view is that after working for almost 22 years in constitutional courts, I should not do any work of adjudication like arbitrations, or I was offered some post as ombudsman. We should not do it. That's my personal view. I'm not saying that those who are doing arbitration are doing something which is wrong. They may be also right, but it's my personal view. After occupying that highest position, why should I do any adjudicatory work? Personally speaking, I have criticized the arbitration in India. One judgment in 2024 and one very recent judgment. Therefore, what I feel is that I should not do any adjudicatory work. There is enough work for retired judges to advise people, to give opinions, enough work for judges. And then I feel that my experience of 20 years in the bar and 22 years as a judge, I should be utilizing by delivering lectures in judicial academies or law schools, law colleges, which I have been doing now after my retirement. So that is my concept of retired life, that use your experience as a teacher, use your experience to give opinion on legal issues, and doing that opinion practice, it has twofold advantages. One is that, legal brain remains active. And secondly, you get some income also.
One last question before we wrap up. I can't help but noticing that despite having spent more than 2 decades on the bench, you don't seem to have aged at all. Despite us at the bar, take for example me, going grey, you look exactly the same as what you were 20 years ago. What is your secret? Can you tell us?
Firstly, I must give credit to my wife for ensuring that I have good diet, for ensuring that I take 1 hour mandatory walk every day, even more than 1 hour. The second credit I will give to the judicial work itself. The work as a judge, sitting in the court, getting ready to sit in the court, reading those files, then sitting in the court, hearing the lawyers dictating the orders, that itself works as a vitamin, and much better vitamin than what we get in market. So, and third thing is, of course, you have to maintain good lifestyle in terms of diet and in terms of regular exercise, which I used to do only walk.
Thank you very much for spending your time and sharing your experiences with our listeners.
Thank you.